Good morning, everybody, and I'd like to welcome you to our Peace Officer Decertification LEC Q&A. First off, I'd like to just kind of go over what we're going to be covering this morning. We will be answering some of the questions that were pre-submitted by attendees, and we also welcome any attendee that's logged on today to send your questions through the chat. And we will, with time permitting, be able to answer those questions that you send in. So without further ado, I'd like to introduce our panel. Representing the Professional Conduct Northern Bureau is Brad Hofflander.
Good morning.
From Central Bureau is Jim Sasso.
Good morning.
And from Southern Bureau will be Daryl Elliott. Okay, so we will start out with some of the questions that were submitted to Post prior to this morning. Brad, will Post decertify an officer if their agency does not intend to terminate them?
Yeah, so at first I thought it was important to kind of explain that Posad itself does not have the authority to decertify an officer. Posad, after conducting a thorough independent analysis of the investigation, can only make a recommendation that the officer certificate be revoked. So it is a responsibility of the board to then make a recommendation that the case be heard by the commission, who then has the ultimate authority to decertify. So in reference to the question, after Posad conducts a review of the case to determine if serious misconduct is defined in Penal Code Section 13510.8 has occurred, making a recommendation to the commission for decertification is separate from any misconduct handed down by the agency to the officer as far as a penalty is concerned. So with that said, Posad may recommend decertification even though the agency itself is not recommending termination of the employee.
Okay, thank you. Jim, what is the most common type of misconduct you see that results in decertification?
Based on the latest information presented to the board and the commission, the top allegations resulting in action by Post are acts that violate the law and dishonesty. Additionally, Post has taken the most certification actions against cases involving acts that violate the law, mainly attributed to the immediate temporary suspension basis of arrest indictment or indictment based on a crime committed in Government Code 1029.
Okay, thank you. Daryl, is there a correlation with officer age in cases you are seeing?
So Post does track demographic data, and we present that at commission meetings quarterly. As far as the specific question, though, they're asking for age related to cases. So that would be reports in our world, or we have, in essence, have 40,000 allegations, and we do not track age as it relates to an allegation. So our method is to track those we take action on. So we're tracking the individuals who we've taken action on. We do have some statistical data associated to that, and but of statistical value, it's very difficult right now. Our sample size is roughly 256 officers out of 82,000 officers, and so the sample size is really small. Needless to say, demographically speaking, the number of cases that we're seeing matches the population of the officers who are in the field.
So just to clarify, every case that Post gets, we do have data that we can obtain that shows the age.
We do have that data, yes. We just have not tracked it at the allegation level.
We can bring back, yeah. Okay, Brad, how fast is the division clearing their caseload?
Well, it varies. Oftentimes, when you receive a case or assigned a new case, you can pretty quickly get an idea of, this has the potential to move forward for decertification. And there's other cases where you look at it and immediately you can see that it's not going to go anywhere. So generally, for those cases that won't be moving forward for decertification, you can generally complete those in a short period of time, usually in 1 or 2 months, depending on what you need for the case to complete it, any follow-up that needs to be done and things like that. And for the cases that would be moving forward for review by the board and commission, it could take anywhere from 4 to 6 months from when we receive the case until it goes to the commission. And so just as a reminder, I thought it would be helpful to mention that when agencies are submitting their investigations or serious misconduct reports to Post, it's important to include everything that is encompassing with that case. Any criminal reports, any exhibits, any appeals by the officer, and basically that helps cut down time for the LECs having to do follow-up after we're basically done with our case. But we need those items just to make sure everything's on board and to close it out. So just a reminder for that. And also make sure that your Mark 43 user information is up to date. We use Mark 43, the user information within Mark 43 to contact the agencies to request that information from them. So if we go to Mark 43 to an agency and they have 5 people listed who are contacts, but none of them are working there anymore, or it's not up to date, it just delays the process in general. So just a reminder on that.
Okay, thank you. Jim, when an officer's certificate is temporarily suspended, what type of notification is required to be made to the concerned employee?
The Post will send a certified letter and a regular letter via mail to the officer's address of record. This letter will explain the executive director's basis for the issuance of the immediate temporary suspension, including any supporting documents. The department head and the district attorney of that county will also receive a letter explaining the basis, but they will not receive any the supporting documents. For this, it's important that the officer keep their address updated via PostPass. It is a commission regulation that the officer notify Post of their most current address, so we can send that information. In the event that we don't have that information, the letter would go to their last known address, which is their agency, and Post cannot ensure that the agency would share that information with the officer. I think there's some questions regarding the updating of address or keeping their address on file via PostPass, whether or not that information is subject to a public records request, and it is not, and Post keeps that information confidential.
Great, thank you. Daryl, I'm curious if there are consequences for the departments who are clearly underreporting.
The underreporting departments, that's a clear violation of the statute. However, there's no specific penalty currently listed in SB2. I will say that we are looking at potentially or considering a legislative update that might address that. One thing that that's available to the public is we are addressing this in our public hearings with the Post Commission. The information in our community/data warehouse is available to see which agencies, actually, I take that back. That's being reported to the commission. However, in addressing that, we know that news agencies are looking at what's being reported to the commission, and so they are searching their local agencies, and they might be writing, we know that they've written reports historically on underreporting agencies in their area. But the bottom line is we're looking for a potential amendment to address that.
Okay, I know you brought up our website, and there's a lot of information that's provided on our website, including statistics. And I want to just ask Michelle Weiler from our certification bureau to just address some of the statistics, specifically age, race, education, that some of our data is being kept on some of the reports that we're getting in.
Yeah, so if you go to the Post website, to the data warehouse, and I can, I guess, walk you through how to navigate that. If you go to the, oops.
Community.
Not where I thought it was, I'm sorry. If you go to the community section, there is a tab on the left side for open data. And if you scroll down, you'll see different listings of sorry, if you click on the right side, post data warehouse. I keep forgetting it goes to the 978 website first. If you scroll down under interactive data reports, you'll see peace officer certification reporting. And that's where you can see the different types of data that we will report out. As of right now, we are working on some other data that once the commission is satisfied with how that data is being produced and what it looks like, we will also make that information public. But there are tabs on how many certificates are being issued, what types of separations, reasons we're receiving, the types of actions that we've been taking and the numbers for those. You can sort them by year, 2023, 2024, 2025. There is a summary of the complaints, charges, allegations, and then definitions of the terms that we use. What is not currently on here, but as Daryl mentioned earlier, we do have data that we are keeping for average age, average years of service, for those that we have taken action against. So as he mentioned, we don't have that specifically available for the allegations because that's a more broad category right now, and we're only focused on those that we take action against. Again, I do have that data. We do present that to the board and the commission at our hearings with them, and we're hoping to make that available publicly soon.
Thank you. Jim, I'm going to ask you this next question. When you receive a frivolous complaint or a complaint where someone who repeatedly makes complaints, is this still a mandatory submission to post?
Yes, the bottom line is yes. All agencies still must respond to any public complaint of serious misconduct by stating that they've reviewed the complaint, and now they may come to a finding of exonerated or unfounded, but they still must report that information to post.
Okay, thank you. Brad, how would you recommend we provide training and direction to make better decisions about when we do or do not submit entries in Mark 43 to post?
Yeah, so let me start by saying that like what we do here at Post in regards to SB2 is still new and evolving. So there will obviously be questions about reporting, procedures, appeals, et cetera. If you do have a quick question and need some direction for a particular case, the easiest thing would be to contact Post directly, telephone, ask for one of the LECs that's representative of the area that your agency is within, so Southern, Central, and Northern. They'd be happy to speak with you and answer any questions you may have or just get some direction on a case. If training is requested, I know Post to be more than happy to conduct an in-person training class specific to SB2. Our bureau chiefs have done several training classes already and are open to extending the offer to any agencies within California. I know the next Mark 43 training class will be held here on November 5th at Post from 8 to 12. You can find all the information on the Post website. It's a free class. You just need to register through the website.
Great, thank you. Daryl, how do you address a retired law enforcement officer who does not want to participate as a witness in an investigation into the potential misconduct of a peace officer?
I guess first I would start by asking that retired officer if they remembered their core values of character and integrity and why they served in the first place. But according to the question, that probably went poorly. Under SB2, SB2 does grant Post the legal authority to conduct investigations. And in this circumstance, though, with a retired officer who's not employed by an agency currently, there's not the element of compelling the officer because there's not a standard. We could not find a violation where they failed to cooperate within the investigation. One thing that I will mention is under 13.510.8C4, Post does have the authority to compel cooperation via the issuance of an administrative subpoena, We've not done that yet with individuals. However, that would be something we do on a case-by-case basis in consultation with legal and our executive leadership. Right. Once.
Okay, Jim, can you talk about the appeal process and the grounds for an appeal?
Sure. After the Peace Officer Standards and Accountability Division makes its determination, they'll notify the officer in writing. Following receipt of that letter, they have 30 days to request an appeal and a public hearing before the Peace Officer Accountability Standards and Accountability Advisory Board, and that will be scheduled before the board. At that public hearing, the findings of the investigation will be presented, and the board will make a recommendation to the commission, to the post commission, for revocation or decertification. The commission will then hear the matter and make a final determination on whether or not to uphold that recommendation or make its own recommendation. If the board moves forward for an affirmative vote in decertification or revocation or suspension, the matter can then be appealed to an administrative law judge. That process is actually outlined in California or the Commission Regulation 1209 and Penal Code Section 13510.85.
So to clarify, if it goes to a board and then it goes to the commission and then it goes to the administrative law judge, there is an appeal process through each one of those steps.
Yes.
Okay. And then after the ALJ, what happens?
After the administrative law judge, the matter is returned back to the commission where they will make the final determination.
Thank you. Okay, Brad. Do you ever encounter any behaviors that may lie within a gray area, making it difficult to determine decertification?
Yes. I'd say probably the majority of our cases will fall within that gray area. So the gray area, I guess if we want to put a definition on it, so you're given a case, you review it, and you're just not sure, maybe it has, the evidence is clear and convincing, or the misconduct itself maybe doesn't rise to that level of decertification. So now you're thinking, okay, well, what should I do with this case? In Northern Bureau, and I'm pretty sure in both the other bureaus, we'll conduct a roundtable meeting with our peers, present the case, throw out, some ideas from other LECs within the unit. Maybe they've experienced similar cases in the past or with their previous employment, and kind of get a better idea of a consensus of where the case should go. Should it move forward or be closed out? So if it's determined that it should move forward, then we'll conduct a review or presentation to the bureau chiefs within Posad. And at that point, it's or a recommendation is made whether or not it should go to the executive office for review.
So it sounds like there's a lot of internal steps before a case would even.
There is,
Well-
yeah. And it's helpful because the majority of the LDCs in here have a lot of experience in investigations, just their work in general. So it's a plethora of knowledge that you can use to help you through those cases that you're not quite sure about.
Great, thank you. Okay, Daryl, can you provide an update on how many cases have been heard through the board and commission?
Yeah, so we've had 5 hearings before the board and the commission relative to serious misconduct cases. We've heard 20 individuals. And so of those cases, the outcomes are as follows. We've got 12 revocations, 4 settlements, 1 voluntary surrender, 2 no actions, and 1 suspension. And that's where we currently stand.
And how would someone view a board or commission hearing?
Yeah, you can go on our public website, and on the homepage, it has a selection for view upcoming meetings. And within that, you can also choose to look at previous meetings because they're all recorded. You can either look at transcripts or the actual meeting itself.
Great, thank you. Okay, Jim, if an officer's post certificate is revoked and they are of retirement age, does the decertification affect their retirement?
No, Post only takes action on the certification, not employment. So Post does not have any involvement or authority in an officer's retirement.
Brad, does serious misconduct need to be reported within 10 days of receiving the allegation or 10 days after the completion of the investigation?
So yes and yes. So Penal Code Section 13510.9 states that you have 10 days after receiving an allegation of serious misconduct that you should need to report to Post. And then 10 days after the final disposition of any investigation that determines serious misconduct did occur. So 10 and 10 on both ends of that.
Okay. Daryl, if Post receives a complaint from a citizen on my agency personnel, will my agency be notified?
Yeah, so our process is once we receive a citizen complaint, we do forward that complaint directly back to the agency unless there's a compelling reason why it might compromise the investigation. And a reason for doing that would be an example of if the complaints against a chief or the complaints against actually the person we're sending the case to, we wouldn't want to send it to compromise the case, I guess. And so in those instances, we treat it on a one-on-one basis. It might go to city council, it might go to a different individual, but we have that conversation at a higher level.
I'm going to throw a little softball into this. Sarah Wallace is the bureau chief for intake and disposition. Maybe she can provide the audience just a snapshot of some statistics of public complaints and how many we've received thus far.
This year we've received, I believe, close to 1,000 public complaints. Many of and when I say 1,000 public complaints, that's regarding one officer and one allegation. There's a lesser amount of public complainants for that total. So we do receive frequent complaints from certain complainants. We do review those complaints if, like Mr. Elliott mentioned, if it's regarding a chief, a sheriff, or a reporter, we will refer those to the bureau chief of that professional conduct bureau to determine whether or not it should be referred to the agency, or if it needs to go to an outside third-party vendor. We work closely with the agencies for complaints that we haven't received adequate information regarding the allegation. Then we'll reach out to those agencies, and IDB is always available. Our contact information is on the website should any agency reporter have any questions about what it is we're specifically looking for.
And does your bureau triage the complaints when they come in? Or how
We're-
does that work?
We're reviewing for, we receive anonymous complaints. We receive a variety of complaints. So we are looking for information regarding what officer it is, what agency it is. We check through EDI to confirm that we're referring it to the appropriate agency. We're reviewing for any allegations of serious misconduct. Even though perhaps the facts of the case may not result in it being serious misconduct, we still refer those cases to the agencies. We're also triaging for frivolous complaints that have nothing to do with serious misconduct. In certain situations, many of those complaints do not end up being referred to the agency because they don't rise to the level of serious misconduct or they're non-jurisdictional. And so we handle those internally and ensure that anybody that has made an allegation of serious misconduct, that those cases go onto the agency, that we're doing follow-ups with the agency, and that those cases are then referred to our professional conduct bureaus for investigation.
Great, thank you, Sarah. Okay, Jim, will Post wait for an agency to complete their investigation prior to beginning their decertification review?
Yes, unless a unique circumstance dictates otherwise. And for example, that might be if an officer is awaiting arbitration or a Board of Rights review, and there's possibility of other facts or relevant information or evidence that might become relevant to the officer's case.
Okay, Brad, if an agency clears an officer of misconduct, but Post does not?
Well, while the results and disposition of any agency investigation are taken into consideration, each professional conduct bureau is responsible for conducting an independent assessment and analysis of any alleged serious misconduct before making any recommendations for action. So it kind of relates back to the first question that we had this morning. I already did my notes here, but it's separate from, or any post action would be separate from the agency's recommendation for disciplinary action, if that makes sense.
Okay, Daryl, is the public hearing process held if the certification is voluntarily surrendered?
So the short answer this person, I believe, is looking for is no. You know, if you voluntarily surrender, you're not going to be subject to any public hearing or process. It's a little bit more complicated in that you can voluntarily surrender at any point during our process. For example, if we are in the beginning where we've not yet even conducted a thorough investigation, we've issued a letter of, or issued a letter of investigation to an individual, and they voluntarily surrender at that point in time, then that would be true. There'd be no additional information on the public website other than voluntary surrender. However, if we go through our investigative process and we're issuing a letter of intent to decertify or take action on somebody's certificate, because we've completed our investigation, if you voluntarily surrender at that point in time, there will be information available on the website as to how and why, because we've completed our investigation. So even though you may not go to a public hearing per se, there would be information available on what the allegations were.
Jim, how does POBAR, Peace Officer Bill of Rights, apply with Post's conducted investigations?
POBAR only applies to the employing agency, which Post isn't. But Post does follow Commission Regulation 1206, which has similar rights, if you will. And those include the peace officer being informed of the nature of investigation prior to any interview, be given no less than 3 business days for notification of the date, time, and location of the interview, have the right to representation so long as the representative is not subject or witness to that matter. The interview may be recorded. If there's further proceedings or additional interviews, the officer will be provided a copy of that, and the officer would be allowed to attend to any personal needs during the interview.
So can anybody on the panel just walk us through, if you wanted to interview a subject officer, what would they expect? Who would like to take that one?
Be the senior with LEC.
Yeah, if you're interviewing a subject officer, is that the question?
Yeah, I mean,
How
are they
would we
going to
go about
receive
doing-
notice? How are they told of the interview?
Yeah, we do the best we can early on in the investigation. Hopefully, we've sent out a letter of investigation to the individual and they may have responded back. The whole goal in the letter of investigation is to kind of develop a relationship with the individual, or at least inform them of the process, the due process that they're looking forward to. If we have an active phone number or a phone number that we can call them with, or they call us back because our number is listed in the information that they receive, that's how we would ideally reach out to the individual and inform them of our desire to interview with them. We do offer, or we make sure that they have representation if that's appropriate, if they choose to have that individual, but we certainly give them notice ahead of time. We let them know what the interview is going to be about. We provide them with documentation ahead of time if appropriate, and we let them know that it's going to be recorded. And I think that's the essence of an interview.
And they're allowed to have representation.
Correct, yeah.
Okay. And are they allowed to record the interview along with your recording?
They certainly can, yes.
Okay, Brad, If an agency makes a determination to terminate an employee and post moves forward with decertification, what happens if the employee gets their job back through arbitration?
Again, it's two separate, I won't say entities, but misconduct from the agency and then decertification from post. Those are two separate determinations. So anything that happens with the agency in the appeal process would be taken into consideration by the LEC as far as the analysis and any recommendations made to move the case forward. But ultimately, if it does move forward, the commission determines that decertification is warranted, the piece or the officer would no longer be able to work in California. And that would supersede the agency's or the arbitrator's determination of reversing any misconduct or a penalty that the officer received.
Thank you. We have a question that came through the chat, and I will look for any of the panel members that would like to take it. Are there any specific enumerated crimes that, if convicted, are automatically fatal to a post certification under SB2? Jim?
Under 1029, there's several crimes, but for mostly, a felony conviction would be a disqualifier. And then a list of crimes, and it's on the website. I don't have those with me, but there's a lot of the 100 sections in the penal code, and those could be reviewed. But those are, if convicted or a guilty plea, those would be disqualifiers.
And those are listed if somebody needed to research that under the Senate Bill 2.
Yes, under 1029 as well.
Okay. I'm going to go back to Jim. What if post does not recommend decertification, but the board does?
Post could also recommend or move forward with a recommendation of suspension. And the board may make their own determination on that.
Anne-Marie's wanted to jump in. Go ahead.
Thanks, Jim.
Yeah.
So the board can recommend a decision to the commission, but the board itself does not make decisions. So Posad or Post makes recommendations to the board for either suspension, revocation, and then the board can independently make a recommendation to the commission. Ultimately, the commission is the only governing body that can make a decision regarding the outcome of a case.
Okay, thank you. Brad, procedurally, will a public decertification hearing be held if there are still criminal charges pending related to the original incident?
Generally, post will toll or delay, if you will, any determination or recommendation for decertification pending the outcome of any disciplinary appeals or civil or criminal actions. So depending on the criminal charges and the court proceedings, this obviously could take several months or even years. I have a good example of one of my cases. The officer was arrested in June of 2000 on some drug charges, facilitating a drug purchase and transporting for sales. 2001 prelim hearing was scheduled. The officer failed to appear. Bench warrant was issued, and he's been in the wind ever since. No one's had any contact with him. Effectively fugitive at this point. I spoke with our Legal Affairs Bureau last week just to kind of figure out what the best course of action would be. So we decided to do ITS, immediate temporary suspension of the peace officer's certificate. He was already past that threshold anyways, or it wasn't active. But it kind of at least put something into place for the officer of being it being suspended. And now we'll just wait until he's found or, the criminal trial is over. So until I hear otherwise. So generally, yes, we'll wait until the criminal proceedings are over until we go forward with the case.
Okay, Daryl, I'm going to ask you, can the commission disagree with the board's recommendation to decertify an officer and decide to allow the officer to retain their certification?
Yeah, actually, Anne Marie just touched on the process or procedures in what the commission can and can't do. The board does recommendations, not findings, and so it's up to the commission to make a determination of what they choose to do with their certificate. They are the final say.
Okay, we got a question that's a little bit lengthy from the audience, and I'll try to summarize it. But I believe Jim might have touched on this topic, but if you could clarify maybe for the person in the audience. Post, it says in other trainings Post put on, we were taught that Post would not take decertification action if the officer had remained employed after a full evidentiary arbitration civil service appeal. Wouldn't Post be precluded from taking decertification action after an arbitrator ruled he or she is to remain employed?
That's an employment action, and this is certification action. So no, we wouldn't be precluded from reviewing that matter and addressing it internally through our processes. And it may, even though it may have, there might have been a separate action at the employment side. Post may make a determination that there's clear and convincing evidence otherwise and move that case forward.
So there's a clear delineation between employment and licensing. Okay, Daryl, how can decertification not be considered punitive?
Yeah, this is a common question that we get. And, it's not lost on Post that there's a correlation between an officer's certification and employment. We are aware of that. However, Post deals with certifications, not employment matters. And so it's specifically up to the employing agency to decide what they want to do with an individual if, in fact, a decertification action has taken place. The common thing that we see, I guess, to better explain this is an officer who's eligible to retire has an allegation of serious misconduct, and then they choose to retire. Regardless of what we do with their certification, it's not going to impact their retirement or their retirement, the money that they receive in retirement. So we don't have punitive action towards the agency's human resource side. And also, we don't deal with criminal matters as it relates to that. Is that clear?
Yes. I'm going to ask Chris Becker from our legal department to address the next question that came through the chat. And it's basically asking about interviewing subject officers, whether it's voluntary, and if it's not voluntary, just the steps of how we would look at a failure to cooperate as it relates to a subject officer interview. Turn on your mic. Turn on your mic.
So under Penal Code 13510.8, failure to cooperate is an independent action for serious misconduct. So, and if an officer was currently employed with a law enforcement agency and they did not cooperate with an investigation into serious misconduct, that would be a separate action that we could take against their certification. If they're not employed, then there's other things I think that Daryl mentioned that under the government code 180 that we have administrative subpoena power, we have deposition power, we can go to the court, we can enforce these actions. So we could subpoena somebody to come and testify. If they don't testify, then we could go to the court to enforce that action. So there are different avenues. It all kind of depends on the officer's employment status at the time.
I'm going to ask you, the panel, or Mr. Becker, maybe to answer this next question. Again, it's lengthy, but I will try to summarize. There was an investigation in which a neighboring agency's IA staff refused to compel their officer to speak to the agency. The subject officer subsequently declined to answer voluntary questions. Does that fall under serious misconduct category of refusing to cooperate with the internal affairs investigation? Would the employee's refusal now require what would be a lower level investigation to be reported to post? So I guess to summarize, if you have a witness officer that works at a different agency, and that agency does not compel that officer to be cooperative with the originating agency, what can happen at that point? Anybody from the panel want to comment, or Toby or Chris?
Okay, so the obligation for a peace officer to cooperate under 13.510.8 is any individual while employed as a peace officer that fails to cooperate with an investigation into police misconduct. So as I'm seeing the question, it's less a issue of who was the officer employed by at the time and what decision was made by that officer's employing agency. The question is this a law enforcement officer who, while employed as a law enforcement officer, is failing to cooperate with an investigation into police misconduct? And if so, then there is a potential for a serious misconduct claim.
Anything you'd like to add, panelists? Okay. Jim, what is the standard of proof for both the board and commission's actions? And what does clear and convincing mean? Sorry, I gave you the answer, but.
Clear and convincing means there's a high probability that the facts are true and can be proven as such at a evidentiary hearing.
Okay. Daryl, can the commission's final decision be appealed beyond the request for review by the officer?
Yes, and an appeal can be made through the California Superior Court. It's known as a writ of mandate. That's what they would file.
That's very impressive.
You're welcome.
Okay, Brad, if an agency suspends an officer, will post then suspend the officer for additional time?
No, again, so the post only has authority related to the peace officer certification. So employment decisions, disciplinary suspensions are independent of any action by post. So the commission may suspend the officer certification in lieu of decertification. And I received some information this morning. So there's been 4 cases thus far in which the commission, instead of decertification, has agreed to a settlement stipulation with the officer. So 3 of those individuals were given a 5-year settlement stipulation, which is basically, from what I read, a probationary period. If they comply with all the terms of the agreement, the original recommendation would be dismissed. And the officer would regain their certification status for whatever certificates they hold. And the other officer was given a 9-month suspension of their certificate. So again, just to be clear, it's not a 9-month suspension per like days off per se, but it's a 9 months suspension on their certification. So at that point, the agency would have to determine he's not a peace officer for 9 months. So we'll have to dismiss him or find another means of this employee to stay with our department in a capacity that's not deemed a peace officer position. So, and that would be obviously up to the agency to determine.
Great, thank you. Jim, what's the timeline for Post to review and come to a conclusion on cases?
Post has 3 years from the date of the allegation to complete its case, but Post doesn't take that long. I believe our average right now is between 4 and 6 months to come to a conclusion.
Just want to clarify for the response on that. So Post has 3 years from the date of the actual final.
Final determination. I might have said allegation, but it's
Determination of the agency. Yeah, thanks.
Brad, I know that many officers are receiving what we call a no further action letter. Can you explain what that means?
Yes. I thought it was important kind of to discuss the initial letter that they would receive as well, which would be and Daryl kind of touched on it earlier, the notice of investigation letter. So when an LEC receives an investigation, generally we'll request that a notice of investigation is sent to the officer. And what that does is kind of provide an overview to that subject officer of serious misconduct and Post and the processes and timelines and appeals and things like that. Also included in that is a voluntary surrender of peace officer certification. Should that officer want to voluntarily give up their peace officer certificate in lieu of having the case made public at a later time. So after a law enforcement consultant has completed their investigation into the case, deemed that decertification is not worthy or the case won't be moving forward, a letter of no further action is sent to the involved officer, letting them know that investigation by Post has been completed and no further action will be taking place at that time. So it basically is a closure letter to the officer, letting them know that everything's okay and it's not going to be forwarded for further review.
And can any of you comment on, we do get a lot of phone calls from officers saying that they never knew that the agency had submitted a case to Post. Is there any mandated requirement that the agency needs to notify the officers? Anybody want to take that one?
Yeah, there's no mandate by an agency to notify their officers. In our training, we strongly encourage the agencies to notify their individuals. There are a lot of agencies with internal policies where they do that. There's not a legal obligation to do it. And so we offer for an officer who's still employed, the easiest thing to do is go to either Human Resource or IA and ask if there's been any allegations against them and or anything submitted to Post that they might receive information back on. If the individual is no longer employed, then I think it was mentioned earlier, you can go on GovQA, do a CPRA request on yourself, and Post would provide you with information of allegations against you. I know we've talked about this in previous sessions, but filling out your address of record, it would be extremely important, especially if you're leaving an organization, because your address of record defaults to the agency you were previously employed with. And if you go through the Post pass process and fill out your address of record, we also actually have a place where you can put your phone number. It's really important for Post to be able to reach out and contact individuals, especially if they're not employed at an agency.
So officers can find out if there's been reports of allegations of serious misconduct. Maybe Brad, you want to just close that loop there?
Yeah, so they can fill out a Post Form 2-366. It's a peace officer request for personal records. That's located on the Post website. That one does have to be notarized and submitted through GovQA. So it's a little bit of a process. The easiest thing might be just to ask your agency if they have submitted. I don't know why they wouldn't tell an officer, but if they are not responding to that, then the other route would to submit that form to Post.
Great, thank you. Okay, Jim, can the board act independently regardless of anyone else's findings?
The board can only make a recommendation to the commission. for action, but they cannot take independent actions. Only the commission has the authority to determine suspension or revocation.
So if we have a case that moves forward to the board and the board recommends not to move forward, what happens with the case?
Doesn't move forward.
Yeah, that case, that recommendation would move forward to the commission. The commission's the one that makes the final finding. So even if the board chooses not to move forward,
Yeah,
it's just a recommendation.
it's a recommendation, yes. Okay, those folks that submitted questions online, they're great questions. If you have anything else, we're just coming to the conclusion of our panel. If you want to submit any further questions, we can take them right now. And the last question I have for Daryl is when an officer appeals discipline relating to serious misconduct at their agency, does that delay the decertification process with Post?
Yeah, both Jim and Brad talked about tolling cases previously. I will say that, the statute indicates that Post may, but is not required to toll or wait on an investigation pending an internal administrative process or even a legal criminal process. However, our general practice is to toll. We are really just interested in investigative information. And so if there's new information that might come from, for example, an arbitration hearing or a Skelly hearing or something like that, we're interested in having a thorough picture of the investigation that we would move forward with on certification action.
Anne Marie wants to ask a follow-up question.
Yeah. Follow-up question to that, just so I don't want to confuse the audience. How does that then perhaps connect to some of our temporary statuses? So yes, we can in fact toll for Board of Rights hearings, some of the arbitration hearings. We know that can be a really extended process. In the interim, if we believe there's perhaps a public protection matter or an issue where we see this poses a risk to the public, what type of interim steps do we take regardless of criminal conviction or criminal investigations pending or arbitration?
Yeah, you're speaking about the immediate temporary suspension process. And so if we do believe there's a potential threat to the public, we take action on the individual certificate to essentially put them, we call it on ice a little bit, but that essentially allows the individual to not have the opportunity to go to a new agency, and it tolls the investigation both internally with the agency has the time to conduct their own internal processes. And then for us, if we're suspending an individual, that becomes a priority matter for us. So we're monitoring that very actively, and we'll take action on it as soon as the tolling elements are no longer in play.
Okay, I think that's the conclusion of all the questions we have, and it does not look like we have any further questions online. I want to give maybe an opportunity for any follow-up, Anne Marie, that you might want to address.
So one of the common questions we get, I know you gentlemen field these questions, as do the rest of our team, Certification Bureau, Intake and Disposition. With 40,000 allegations, how do we even begin to triage what comes in, not just with public complaints, but generally speaking? How do we get through 40,000 allegations to ensure there's not some sort of, priority public welfare matter that we're not touching for a period of time? If any of you want to talk about our prioritization.
I'll go. We have multiple triage processes in place, and so I would probably move to the Intake and Disposition Bureau, but we start in intake. So where the allegation initiates, our Intake and Disposition Bureau, they triage the case based on, and then we prioritize it upon entry into Post. Once that process is started, it gets passed out to, we're specifically in 3 areas of the state. And so those investigations would have a prioritization attached to them, and then that would be passed to one of the 3 areas within the state. At that point in time, a bureau chief will once again triage the case and make a decision of where does that get assigned? Does it get assigned at a lower priority level, or is it something that's a priority matter that needs to be addressed with a more sophisticated investigation? Does that answer? You want to add in, Sarah?
I'll add just a few things. So when Intake and Disposition Bureau receives agency misconduct reports from the agencies, we are thoroughly reviewing those reports for the information relating to the officer, the agency, the date of conduct, the allegations that have been made, and then we prioritize that and communicate that to the Professional Conduct Bureau. So those reports are prioritized based on at a higher priority if there's any sustained finding, at a slightly lower priority if there's a not sustained finding or exonerated or unfounded. We ask for follow-up questions if we find that we're missing information that would not lead us to be able to prioritize correctly. We also look for any qualifiers that would rise to the level of a temporary suspension order. And we notify the bureau chiefs immediately so that those cases can be prioritized and brought to executive office in the interest of public welfare, so that those are taken immediate action. We frequently follow up on agency. We do receive open cases. If there's any open reports of misconduct that are still being investigated by the agency, we are looking at the narratives for additional information that would determine whether or not we need to take immediate action so that the Professional Conduct Bureau will be alerted to follow up with those agencies to get that necessary information.
Additional follow-up question, and just could be an estimate. To put this in perspective with, upwards of almost 40,000 allegations, what percentage would you say actually are sustained allegations or sustained findings, coming from the agency that Post would begin to prioritize?
It's been a minute. I think it's a relatively low percentage of the cases that we would actually be taking action in perspective of what we receive. I think it's close to 2 to 3% is what we're actually seeing in terms of sustained findings. The majority are unfounded cases that we're receiving or open reports that they are reporting within the 10-day allegation timeframe.
Okay, it looks like we have no more questions. I'd just like to offer up that we have a quarterly newsletter that we do submit and is posted on our website under the decertification page. And in that newsletter, you'll have all the contact information for all of our consultants for each of your bureaus that if you need their contact. And this session is recorded and will be posted on our website also on that same page. So I want to thank everybody for attending, and we'll see you next time.